Thank you kindly. Well, hello everyone, and thank you very much for joining this session. And it's all about the employment law updates that are relevant for 2024 and beyond. My name is Roy Magara. I'm an employment solicitor by profession, and I have my own employment law firm, Magara Law, where we help both employers and employees across the country, both in England and in Wales. All the details are on the screen there, as you can see, but principally, it's all about giving you all the information that I possibly can in the sort of 45 minutes or so that we do have on employment law. Now, a question for all of you that I want you all to think about, and I'm going to come back to you all in about 20 minutes or so for your thoughts. And that question is this: if you could ask an employment solicitor, yours truly, one thing, what would it be? So I'll repeat that again. If you could ask an employment solicitor one thing, what would it be? And I'll come back to get your questions, as it were, your answers to that question in a short while later. But first, and Tracy, you can kind of go to the next slide. First, I just want to talk about some employment case law decisions that are going to be expected in 2024, which are quite likely to have an impact on, well, one will certainly have an impact on most people, certainly if you're in HR. And the other one is just a particularly interesting case to do with AI, which seems to be talked about quite often. So the first particular case is one called Bathcade and Technip. I won't bore you with the detail of that particular matter too much, but essentially the question that the tribunal had to figure out was, can you negotiate a deal with an employee to settle a future claim which hasn't arisen yet? So as some of you may know, typically a settlement agreement is often used to help manage the exit process of an employee typically. And the main thrust of a settlement agreement is that they agree to leave the employer, typically for a sum of money, in exchange for confidentiality and waiving all rights and claims against the company. Now, in this particular scenario, the question had to be answered by the Court of Session in Scotland. So it coincidentally wasn't an English and Welsh case. However, the principles of that can quite affect us here in England and Wales. Now, the question that had to be answered was indeed that there was an individual who potentially had a future claim that he didn't know about at the time that he signed the settlement agreement. And the settlement agreement had a fairly kind of general clause in there about you waiving all rights and claims against your employer that you know about now, but also any future claims that you may not know about. And that's actually quite a standard clause typically that we see in our own settlement agreements here in England and in Wales. However, the employment tribunal agreed with the employer. It was then appealed to the Employment Appeal Tribunal, who agreed with the employee, saying that in actual fact, the relevant claims that he would have had, which were to do with age discrimination, ought not to be caught within that particular clause because he couldn't have known about it at the time. It then went to the Court of Session, which is the kind of Supreme Civil Court version that we have here, but in Scotland. And they ruled that the relevant legislation, being the Equality Act, didn't prevent the settlement of claims unknown to the parties at the time that the agreement was signed. So the agreement in that particular case was sufficient to waive any, in that case, age discrimination claim, as it fell within that general waiver clause. It wouldn't be sensible, the Court of Session had ruled, for both the employer and the employee to be bound by things they simply could not know. And then the employee would have a right in X amount of time, and that kind of ruins the whole point of settlement agreements in and of itself. So in short, after all that effort for the poor employee, he didn't get what he wanted in the end. The ex-employee, in short, could not pursue his claims for age discrimination. Then there's another interesting case called Manjang, and that was against Uber Eats, some of you may or may not know about. And in short, that was all to do with facial recognition software, which the employee had to use to log into his app when he kind of like a clock in and clock out system. And the question essentially that the tribunals have had to figure out in this particular case is, was it race discrimination for Uber Eats to use that facial recognition software to verify the identity of platform workers? Now, it may help to give some kind of context, because that's quite a general statement, is simply using face recognition software racist? Well, I would quite quickly hasten to add that the answer would be no. However, the context of this particular case was that the AI software that Uber Eats was using, for whatever reason, could not recognize this particular employee's face, in short, and so he was never able to log in, and that led him down performance and incapability routes within the employer. His position was actually the AI software didn't recognize him because he was too dark, essentially, and that essentially was the issue with the AI. There were continual mismatches in the photos and in the software. And very long story short, um, Uber Eats had sought to try and strike out the claim. The tribunal refused to do that. And in short, Uber Eats eventually paid out to end the legal claim following those allegations. So it didn't end up going down to a final hearing in the end, but they paid out. How much, we don't know. But it seems to me the main thrust of that is, if you're going to use AI, which in and of itself is fine, you just got to make sure that particular groups of people aren't disadvantaged because of that. And that was the main issue there. Very interesting, in my view, at least. You might think completely otherwise, but that's certainly my view. Uh, let's move on, please, to the following slide, Tracy. Now, there's been much talk about flexible working over the years, and where on earth are we now? Well, the short version is that employees now have a day one right, shall we call it, to request flexible working arrangements. And I always have to add this, because often when we get inquiries about this, employees aren't quite clear on what that means. So there is a right to request flexible working from your first day of employment. However, that does not mean that you have a right to work flexibly. Those two are two different things altogether. So previously, as some of you may know, it was an employee had to be in service for at least 26 weeks. That requirement has now gone. Employees can now submit 2 flexible working requests in a 12-month period, and employers are still required to consider all requests seriously and consult with the employees before making a decision. So again, employers have a right to make a flexible working request, but they don't have an automatic right to flexible working. Two different things altogether. All right, let's move on, please, to the next slide. This is fairly factual in nature. We're coming to the end of April, so hopefully most of you have made the changes you need to already. What's on the screen is fairly self-sufficient, so I'm not going to go into too much of an explanation to do with that. However, what I will say is a couple of significant changes, or one significant change, that being that the national living wage age has now gone from 23 to 21. So previously it used to be 23, and indeed from April this year, from 6th of April this year, it's now 21. So make sure you make the relevant changes. The national living wage, as you'll have noted, is increased now to £11.44, and the rest you can see on the screen have increased thereof. So the most significant thing I'd suggest noting is just the age reduction from 23 to 21. All right, let's go to the next slide, please, when you're ready, Tracy. And before we talk about what's happening with protection for pregnant employees, I just want to go back to my initial question that I'd posed to everyone to ask me a question. If you could ask an employment solicitor one thing, what would it be? So feel free just to unmute yourself and ask, or you can put your question in the chat box, and I'll pause for a moment.
Well, I'd say, can you renegotiate contracts?
So by that, do you mean an employment contract?
Yeah. So for example, somebody's been working with a company and then they found to chat with other employees that they've got like an extra benefit that they negotiate at the very beginning of their contract before they started, and then say somebody think, oh, that's not fair, I don't have that. Can they go and sort of ask? Well, I suppose anybody can ask anything, but does your employer have to take it serious and then maybe consider offering that same benefit across the board?
Sure. So I suppose it's twofold. I suppose the general answer is yes. One can always try and negotiate, as you rightly said. Anything and anything can be up for discussion. I suppose where an employer may want to take particular caution is if there are, for example, two employees doing a similar role and they just happen to be two different sexes, for example, and there might be a gender discrimination claim waiting in the background. So to give an illustrative example, we've got two legal assistants here at the moment in the firm, one male, one female. If one had more benefits than the other or had more salary than the other, without there being some kind of justifiable reason, then the other employee could quite easily say, well, it seems the only difference between the two of us is our sex, and they'll end up bringing a sex discrimination claim, for example. So general rule, yes. However, when you kind of look to try and particularize it, what exactly are the things that are being raised? And if so, could there potentially be an issue of a sex discrimination claim? Does that help, Kevin?
Yes, yeah. Well, because there's a couple of people that have this ability to like work part-time from home, but other people don't have it. And it was just if ever anybody brought it up and said, well, they can work from home 2 days a week, how come we can't? And does because it's already like a precedent being set because there's already somebody who can work flexible from home, for example, does the employee have to then say, okay, then you can also have 2 days, 1 day, whatever, working from home?
Yeah, so it seems to be, Kevin, that what's happening with these employees who have a particular disability and therefore need to be able to work from home for X amount of time. That's what we call a reasonable adjustment. In other words, you are endeavoring to set them up on the same level as everyone else to ensure that they can do their job as properly as possible in light of their disabilities. That doesn't then give everyone else the right who may not have that disability
Mhm.
to then, for example, in this case, work from home. And I suppose the challenge that you may have in that sort of scenario is balancing the confidentiality that you have to set employees versus ensuring that all employees feel like they're being treated fairly.
Mhm. Thank you. Cool.
Sure thing. Anyone else?
Roy, there's some questions that we've got in the chat for you.
Ah.
So extending employment contracts, how many times can an employer do this?
Sure. So just so I can double check the context, is that in the context of fixed term contracts?
No, permanent roles. For permanent roles.
Yes. So if it's a permanent role, you're talking about extending employment contracts.
Yeah. No, what I meant is their probation period. You know, they keep extending their probation period. Sorry, I didn't make that very clear, did I?
That's all right.
Yeah, we've got a client who seems to have a pattern emerging where they take on new people, but constantly try to drag out their probation period. The reason for that, I really don't know. But I wondered how many times they can do this.
Sure thing. Yeah, great question. So two things you often find. One is this particular issue, and there's another issue whereby sometimes employment contracts will say under their probation clause something along the lines of your probation is going to last, let's say, 3 months, and we will confirm to you in writing if you've passed your probation. If you don't get any confirmation in writing, then just assume that your probation continues until you eventually get said confirmation in writing. And that can be X amount of time further down the line. That in and of itself, particularly when there isn't some kind of paper trail at the point of what ought to be a transition from probation to standardized employment, can be an issue. But where there are instances where an employer continues to prolong a probation period, it's got to be justified first and foremost. Typically, it is to do with performance. But where an employee may believe that there's some bias or less favorable treatment behind it, and I appreciate often it's not that obvious, then there needs to be some fishing perhaps, or some homework to be done in terms of what genuinely is the real reason. Is it to do with a protected characteristic, for example, race, gender, marriage, the list goes on. But if it's not that, and the employer simply being, for want of a better phrase, difficult or stubborn, whatever the case may be, there is no number. There is no number that I can give, legally speaking, at least, to say they can only do it twice or thrice. I dare say there comes a point, of course, where it becomes a bit silly. However, what can an employee do about it? Not much, unfortunately, unless it's, as I say, a discriminatory reason, or there might be something else behind that. At the moment, there isn't a right to claim unfair dismissal unless you're under
Yeah.
2 years, unless you're over 2 years, I
Yeah.
beg your pardon. I'll come to a bit later on about the impact of the general election if
Okay.
Labour get in, for example, because they have different thoughts and proposals about things like unfair dismissal. But at the moment, under the Conservative government, should they get in, there are no plans, at least that we can see at the moment, to change that particular rule.
Okay, I suspect it's more a business reason. I think they're waiting for a contract to be signed, and there's less implications on them if they're not officially members of staff. But it's not setting a very good feeling amongst the department. But hey ho, thanks for
No,
that, Roy.
really.
Really appreciate it.
You're
By the
welcome.
way, I've got my image gone because my network is really bad.
Bless you. We can hear you just fine, Belinda. Thank you. Next question we've got in the chat. What is the most common issue employees take to a law firm, and what causes that to happen? Thank you for your question, Sam. I'd say nowadays it's twofold. We got a lot of discrimination instructions at the moment, whether rightly or wrongly, as it were. We certainly get a lot of those, and I think a number of things have propelled that. There are a lot of, well, from the COVID times, such shall we start with, BLM caused a real big rift in some ways on the topic of race and discussion, how people are perceived, or how they think they're perceived, but they may not be. COVID then, of course, equally meant that it caused a lot of division and people setting themselves into various camps and sticking with that and not having what we would have typically had in terms of normal social interaction, particularly when we were all locked indoors for such a long time. And then following from that, we've had Russia, Ukraine, we've now got Israel and Palestine. There are a lot of divisive issues that cross cultures and nations and political opinions. But certainly that has meant, unfortunately, that discrimination cases, not just to do with race and religion, but also to do with gender, are on the rise. And I think that is one of the reasons why the Conservative government has been looking to implement the Workers' Bill, which I'll come to talk about in just a moment. But in short, that particular piece of legislation, which is coming in later on this year, places a greater onus on employers to ensure that sexual harassment doesn't happen in the workplace. And one startling fact just on that particular point alone is that you're something like 3 in 5 women in the workplace have suffered sexual harassment. That's incredibly, incredibly bad. And to make it even more unsavory, there's another statistic that was something along the lines of 2 in 3 women between the ages of, and I'll double check it, but I want to say it's between the ages of 21 and 34 have experienced sexual harassment. Again, particularly unsavory. So discrimination is very much up there. Another one that is becoming quite common is whistleblowing, a whistleblowing detriment. So people are becoming much more clued up on the things that their employers should and should not do, and they're also becoming more galvanized in being able to speak out about it. But unfortunately, equally, when an employer finds out about it, that means that they either dismiss the employee, find some other way to cause that employee to suffer detriment in some way, shape, or form. So to answer that question more directly, in conclusion, is discrimination and whistleblowing claims that are becoming more often seen. Last question I've got
Thank
here
you,
is
Roy. That's really, really interesting. Sorry, did I interrupt
no, that's
you?
at all, Sam.
Apologies. Because we do get an awful lot of small queries we work in construction, and we get a lot of small kind of under the radar queries about whistleblowing, and under the radar queries about, because I'm this, does it mean that? So that's really interesting. Thank you for that. It's given me a lot to think about.
You're very welcome, Sam. Thank you for your question. And Oscar, you've highlighted how useful is an occupational report in supporting an organization in general. I rate occupational health reports for a number of reasons. One, we're all experts in something, I'd like to think, but not all of us are experts in everything. And that comes down to how someone's medical condition or health can affect them at work. So while, for example, take ADHD or ADD, for example, there's such a wide spectrum of what that is and how that affects an employee and how that affects their work as well. And we've got to appreciate that everyone is unique and everyone is different in how that, for example, in this case, ADHD or ADD may affect them. And so what an occupational health report does is at least we get someone who's an expert in that particular condition and how that directly affects the individual at work and how the employer can support them as best as possible in the workplace. It also adds, in my view, as particular protection for an employer, because should, for whatever reason, a situation turn sour and the employee decides to, for example, leave and bring a claim, an employer can at least say, listen, we've taken on occupational health, we've taken on all that they've suggested, we've put these things in place and implemented the best that we can do. For whatever reason, the employee decides to still bring a claim. That acts as a good and valid defense for an employer in that particular scenario. So it absolutely works both ways. Yes, it's a cost to the business, but it's a much cheaper cost than having to defend a claim, for example, at an employment tribunal. Does that help, Oscar?
Yes, Lisa, thank you so much. Quite clear and precise.
Okay.
Thank you.
You're very welcome. Anything from anyone else or anything we've discussed? Any questions?
I was going to ask a question, Roy. I've got, where's the best place to update yourself in employment law, apart from listening to yourself? But if we've got something, where else could we, find things?
Indeed. Sure. And hello, Amanda. Thanks for joining.
Sorry, I couldn't get in.
Not at all. You're very welcome. We're just having a discussion on questions that you'd like to ask an employment solicitor, i.e. me. So if you think of one, you're welcome to put it in the chat or just ask away.
Okay, thank you.
But currently Tracy has asked a question on where best can one find anything to do with employment law updates. Well, I suppose being somewhat biased, on our law firm's website, we provide updates on employment law fairly regularly. The firm has got a YouTube page as well, where we often put out employment law updates and answer some of these questions that we've put in here in the chat today. So it's just Magara Law. You can put into YouTube, you'll find it there, or indeed on the firm's website. The website was on the first slide, but will also be on the last slide as well of this particular talk. Aside from, of course, just doing one's general research, but if you want more pinpointed answers, that's what I'd suggest.
Thank you very much.
Sure thing. All right. So I'll give maybe a few more seconds in case anyone else has anything to ask, and then we'll move on.
Belinda has put in the chat function that she'll email details later out to people. So thank you, Belinda.
Thank you, Belinda, indeed. It sounds just typing.
I
So
have to put the mic on. You're welcome, is what I said.
All right. Well, I'll continue. I appreciate Sanya typing. I'll come back to your question if indeed it is a question after I've finished off this slide. So, extended redundancy protection for pregnant employees. So pregnant employees and those on maternity leave are now able to benefit from what we're going to call extended redundancy protection. This change, in brief terms, safeguards their jobs during those sorts of crucial times, so maternity and pregnancy. Redundancy protection now begins at the very start of pregnancy and continues for 6 months after returning from maternity leave. This started from the 6th of April this year. Previously, to give some context, this protection used to begin when a woman informed her employer of her pregnancy. But now the protection starts as soon as a woman becomes pregnant. And as I say, that protection lasts until 6 months after the return from maternity leave. So similar to the flexible working point, this doesn't mean that a pregnant woman can't be made redundant, because if there's no job, there literally is no job for one to come back to. It just means that a pregnant employee or one who's on maternity leave for at least 6 months following their return has got extra rights, is protected in comparison to other employees who are not pregnant or not in that period of maternity leave at that particular time. Okay, let's move on please to the following slide, Tracy. I just wanted to spend some time talking about some regulations and laws that are to come. So we've got some coming in July, September and October. And again, I know that there's a general election coming up, and I'll give you a bit of a steer in terms of what may or may not come to pass depending on who gets in. All of these changes so far, as I've highlighted already, are to do with the Conservative government, and indeed should they continue as much as can be foreseeably predicted. And the first, for those who work or have anything to do with the hospitality sector, this will mean something to you, or indeed any sector where your workers may take tips. So from the 1st of July, workers will be entitled to 100% of the tips they receive without any deductions from their employer, other than reductions required by law, such as tax, for example. So the tips must be paid to workers by the end of the month following the month in which the tip was paid. So tips received in April get paid in May, for example. Although, of course, it's from July. And employers must have a written policy as well, explaining how tips will be allocated and maintain records of tip allocation for at least 3 years that workers can access on request. So again, you just got to bear that in mind, those of you who are in the hospitality sector or those who your workers take tips as part and parcel of their work. The next change that is likely to come in is coming in September 2024. So this is to do with the right to request a more predictable working pattern, and this typically is for those who are in who might have 0 working hours or zero-hour contracts. And that right, as I say, is going to be implemented in September 2024, and that predominantly is for those who currently work unpredictable working schedules. So employers will be able to request a more stable schedule that aligns with their needs, as opposed to the employer having the ability to dictate that. And employers will still have the right to decline those requests for what it's worth, but they have to provide clear justifications for doing so. So that request could include, for example, fixed hours, set days off, or even a guaranteed minimum number of hours to work as well. And as I say, it is not a right to it, it is a right to request it, and employers have to consider those requests seriously and consult with employees before making that decision. Now, I hinted at the Worker Protection Act earlier in the context of sexual harassment, and I can talk about it in a slightly bit more detail now. So one of the most anticipated developments in employment law this year is what's called the Worker Protection Act, and it comes into effect on the 26th of October this year. And in brief terms, this act will place a legal obligation on employers to take proactive measures. We're yet to know what proactive measures actually means in practice, and more guidelines on that will follow in due course. But employers have got to take more proactive measures to prevent sexual harassment in the workplace. And I told you about some stats earlier. 3 in 5 women have experienced sexual harassment at work. That's startling. And that's almost 2 to 3 women as well. Age between, it's actually 25 to 34. Those are quite startling facts, I'm afraid to say. And that doesn't mean, of course, that men equally don't suffer sexual harassment in the workplace. Men do too, but the stats are incredibly disadvantaged towards women. So let's move on to the next slide, if we may. Thank you. And I just want to talk about, again, what the impact of a general election in 2024 may be. So with the next general election quite widely expected to take place in the autumn of this year, whether the Labour or Conservative Party being the 2 likely typical parties to get in is yet to be seen. But we'll spend some time talking about Conservative proposals and measures, and I wanted to spend some time just talking about, if the Labour Party is successful and gets into power, what could the employment law landscape look like? What could the employment law landscape look like under a Labour government? And in short, actually, it could look quite different. There are lots of things that they propose, but I just want to focus on 4 of them. Now, the first is to do with unfair dismissal rules. At the moment, if one wants to bring an unfair dismissal claim, exceptions aside, you've got to at least have 2 years' worth of continuous employment within an organisation. Well, the Labour government is proposing to remove that that cap, you would have a day one right, as it were, to bring an unfair dismissal claim. So Belinda, for example, you were talking about employers who continually push forward or back a probation a probation review or probation transition into permanent employment. Well, at the moment, there's not really much an employee can do unless it's, as I say, a discriminatory point or there's some other exception, which I won't go into at the moment. However, if we were under a Labour government and they proposed this removal of this 2-year cap, an employee in that scenario could say, well, you know what, you've extended my probation twice. I've been here for 6 months, a year. You haven't given me any justification for doing that. I'm going to consider myself unfairly dismissed. Now, not only is the Labour government proposing to remove this 2-year cap, they're also proposing to remove the cap on the compensation itself. So to contextualize that, there are all manner of rules and exceptions, but the general rule is an employee can only, at the moment, receive up to a year's worth of their salary. Well, it's the lower of two, the lower of 90 or £1,000 or their annual salary, which for most people is going to be under that. However, under a Labour government, they are proposing to remove that cap, and it's, theoretically speaking, unlimited in nature. So employers are certainly going to want to watch that. At the moment, lots of employers who have employees under 2 years don't really follow their disciplinary procedures to the T, the grievance procedures to the T, because they think, you know what, as long as we pay our employee their notice pay and any other contractual payment up to the point of their dismissal, that's all we need to do. Don't need to worry about it. They can extinguish all claims. However, the landscape will certainly change in this regard if Labour get in and they implement this particular change in the law.
That's really helpful. Thank you, Roy.
Yeah, sure thing. And then moving on from that, a number of other things that they're looking to do is on employment status. So a number of employment statuses at the moment, whether one's an employee, a worker, self-employed, there are all manner of issues to do with IR35, which I won't go into. But in brief, one thing that Labour is also proposing to do is to move to what they're calling a simpler two-part framework for employment status. So they'd abolish the kind of 3 categories that we have now, and then move on to you're either self-employed or you're a worker. I dare say, probably simplifying it a bit too much. They're going to have to do some work into what defines a worker, and that's why we might end up with so many other subsections under that. But in brief, they're trying to simplify it, but we'll see if they do get in, what that looks like in reality. On the topic of 0-hour contracts, what Labour are saying that they would look to do is to ban 0-hour contracts altogether. So Conservative government, as I've talked about a short while earlier, are looking to try and give employers the power to request a more flexible working arrangement. Labour would propose to ban 0-hour contracts altogether and ensure that anyone who's working irregular hours of 12 weeks or more has the right to a regular contract. That's quite a distinct change. And the last one I'll highlight is further pay gap reporting. So at the moment, most people will know about the gender gap reporting, for example. Well, the Labour government will be looking to introduce ethnicity and disability pay gap reporting. So they're looking to widen the scope to not just gender, for example, that we have it. And so it'll be interesting to see where the disparity may lie, if indeed it does exist. But also it'll be interesting to see which organizations or businesses are obliged to carry out ethnicity and disability pay gap reporting as well. So it will certainly be more homework for those in HR, certainly for those in companies that are going to be caught by that. Now, of course, it doesn't mean that from the autumn, for example, if Labour got in, all of these would be introduced. I think Labour have promised or are looking to try and bring in these sorts of reforms within their first 100 days. So it could be significantly soon, but equally, it's also unlikely that because most reforms don't actually take place that quickly, It may well be that these changes aren't so immediate and they take place over a period of time. But those are some of the changes that one can look out for. Should Labour get in? They may well not be, and this whole particular section is completely irrelevant. And then you just got to think about the things that we've spoken about already. But if they do get in, expect some of these changes that we've talked about just now. All right, so we'll move on to our next slide, which actually I think means that I'm passing the baton over to the rest of you for any questions, comments, concerns, complaints, or otherwise. And Sam, thank you very much for your comment in the chat as well. Grateful to be of help.
Oh, you're welcome. I just think when our colleague on here said, or he said rather, where else can you look? It can get really overwhelming. So I just think sometimes it's better just to kind of think where you are as an organisation, think what is your niche, and then look. But I do think these sorts of webinars are really helpful and most appreciated.
Thank you. I'm grateful for your feedback. Thank you. All right, well, over to the floor, as it were, for any questions, concerns, or otherwise, or comments on anything we've discussed. There's some people in HR too, so it'd be great to hear your thoughts on some of the things that we've discussed.
Roy, can I ask, when an organization has put in, or an individual has put into an organization a request, like you're saying, these are requests, whether it's right to flexible working, whatever the case might be, and then the employer declines, gives reasons for it, and the employee does it again twice, what other action can the individual take thereafter?
Well, it depends what the request is. If it's a flexible working request, for example, you've got your two formal shots at it, as it were. If, as an employee, you still disagree with that and you think that there is some unlawful reason why that request hasn't been granted, whether they're given their reasons or not, then the only other option really that you do have is to escalate it towards an employment tribunal. So rather than push that nuclear button, I suppose at that point, I suggest take legal advice on it, because oftentimes, even though an employee may feel quite strongly about their position, taking legal advice and getting an objective opinion might well just allow them to get that further understanding that actually, despite how they might feel about that situation, the employer has actually acted fairly, given their reasons. Or indeed, it might be the case that the employment solicitor agrees with the employee in that regard and can advise them what to do further after that.
Okay, thank you.
Sure.
Roy, how do you think it'll affect students when students tend to have, they work with one employer at home and then one employer at university with regard to the right to flexible working? I can just see that as being a bit of a loophole for the employer to say, well, if you've got two jobs, how can I be flexible?
Sure. Can I just double check the context of that in terms of them working at home and at university, Sam?
So students, when they're working for more than one employer. So for instance, I was talking to a young lady the other day who's a friend of my daughter's, and she has a job in two different companies, both in the same industry, both are zero contracts. So when she's in one part of the country, she gets her hours. In another part of the country, she gets her hours, but she has a crossover in 2 months of the year. And she's saying, well, they both want me to work. How can they be flexible about that?
Yeah, I hear you. So I think it's twofold, particularly with 0-hour contracts. Yes, the employer can say, right, here are your hours, but the employee also has the right to say, actually, I can't do these hours because of A, B, C, D, E, F, G.
Yeah.
And part of the foresight that helps with 0-hour contracts is that this particular individual ought to be able to say, actually, my term time months or hours are X, and my non-term time hours, or when I'm available or not available, is Y. There isn't really much that the employer can do about that, really, particularly if she's saying I'm physically not here and able to work. In somewhat frank terms, that's the employer's problem to try and figure out and source their staffing, but they shouldn't make it the employer's issue here.
Yeah, I said the same. I said they can't expect you to work out of whenever university finishes, but she's at a private organisational university where they have different types, and it crosses over with where her home base is. So it was a bit complicated, and my advice was just literally just say you can work until this date in here, and that date starts there, and you would love to come back in September, and if you get a problem, let me know.
Yeah.
But I don't think there is anything. I think because it's 0 hours though, and with the changes that are going to come from October, then would she have a case based on if the one back at university said, well, you haven't got a job anymore?
Yeah, potentially so, but I suppose with somewhat unfortunately, when it comes to these cases involving 0 hours, yes, the answer is one would quite likely have a case. The question is, what are they going to get out of the case?
I know, exactly.
And the amount of
Nothing,
legal
other than
fees
a
they
load
may
of
end up
arguing.
spending. Quite
Yeah,
right.
my argument, mine to her was pick who you think you are most happy with, keep them happy, and look for another job somewhere else.
Yeah.
Because I don't think you'll get anywhere. But that's what I say about looking in lots of different places for advice. I think she'd gone to about half a dozen different sources and got herself really confused. And she's only a young girl in her 20s. So appreciate that. Thank you.
With you on that, Sam. Sure.
Thank you.
Anyone else?
Just a question for you, Roy. I've got a number of clients who, during COVID, brought people in on working from home contracts. Obviously, COVID's over, well, potentially over with regarding work. And they're trying to bring them back in the office and failing quite badly, really, because their argument is, I work at home fine. Why do I need to go in the office? So they're trying tactics like a 9-day fortnight or 4-day week, but you have to be in the office. How can they enforce that, or can they enforce that on somebody on an original contract? Can they change your contract midterm?
Sure, great question. And it's no surprise that employers are still struggling with this. I'll answer that question in just a moment. Another potential change that Labour may want to bring in is the extinguishing of what's called fire and rehire that employers are currently able to do. And I'll come to that context in just a moment. So I suppose the starting point is, what does that employee's contract say to begin with? If they were employed before COVID, it quite likely says they should work at wherever the office is based. And then, of course, COVID happened, and for understandable reasons, where possible, most people were told to work from home. Now, post-COVID, the short version is that an employer has absolutely every right to say, listen, for this period of time, you'll work from home. I get that, but it was because there was an international emergency called a pandemic that happened. But your contract says you're based wherever the office is, wherever the site is, you've got to come back. An employer is perfectly entitled to do that, irrespective of how the employee may feel about that, how they've changed their life, their lifestyle around that working from home arrangement. If the starting position is the contract says you can work remotely or you can work from home, and now the employer is trying to change the employment contract to say, no, come to the office, that's where the problem lies for the employer, because the contract says what it says. And unless the employee agrees, then an employer ought not to, but choose my words carefully, ought not to unilaterally change the employee's terms and allow them back and tell them to come to the office. That's where you have this thing called fire and rehire, as it's colloquially called, where essentially the employer says, right, we're terminating your current contract and we're offering you another one, the main difference being your place of work. If you refuse that, well, you're dismissed. We'll pay you your notice pay and all that kind of thing, and off you go. Now, at the moment, context specific, believe it or not, an employer is allowed to do that. There may well be cases where an employee's contract actually does say you are working remotely, you work from home, whatever the case may be, and the employer then is still trying to get this employee back into the workplace, trying to use the fire and rehire technique. Well, an employer may well do that, and an employee may well try and bring an unfair dismissal claim or breach of contract claim or otherwise. What the employer's uphill struggle may well be is trying to prove that there is a genuine business reason as to why that effect had to take place and why the employee couldn't quite sensibly work from home. Most employers nowadays will say, well, it's about team cohesion, it's about performing better in the workplace, it's about that kind of learning by osmosis kind of thing. But if the employer's strapline is, well, all that I was doing beforehand and reaching my targets, I can perfectly do that at home, an employer may well struggle to win that kind of claim, will be my point of view. Does that help, Belinda?
It does, and it raises another question. If they want to implement this moving forward, the 4-day week or a 9-day fortnight, and they bring new people in on this contract, leaving people on their existing contract because they won't adjust and they don't want to lose them, what kind of problems are they going to run into doing that? Are we then going to get people saying, well, it's not fair, Joe down the road, is working this and I have to do this? Can they say, well, it's the terms of your contract and leave it at that?
They can do, but as you rightly say, it does cause a problem from a harmonization perspective. Is an employer going to be quite happy with this sort of fairly chaotic timetable of who and when is in the office, or are they going to try and streamline it along the way? And it depends on the size of the organization and who's doing what. For some, that 4-day week may be appropriate, and for others, depending on the job, it may well not be.
Yeah.
But if they're going to be in this transition of, as a company, we want to move toward a 4-day working week, it's best to try and harmonize those contracts as best as possible. But you're not going to please everyone. Expect turbulence, and you've got to figure that out as time goes on.
Okay, that's really helpful. Thank you, Roy. I really appreciate that.
Sure thing, Belinda. Anyone else?
Roy, you said about the Labour government may change from having being a worker or being self-employed. What does that mean for limited companies? What are they saying?
Yeah, indeed. So limited companies in and of themselves would be separate, as it were, as an organization. So this is more to do with, as an individual, what's your worker status?
Okay.
What's your employment status, i.e., so a director, for example, would quite likely still be a worker. You're either employed by the company or you might be a consultant for the company, in which case you still come under the term of worker under the Labour government, because you're still employed, as it were, by the company or a consultant for the company. But this is what I meant by Labour still having some homework to do. They're talking about simplifying it. Oh yeah, just have worker and self-employed. But actually, what does that still mean? Because there's still so many types of what a worker could be, and so many tax implications for each particular subsection as well. So I don't think it's as simple as they're trying to make it.
No,
but
most definitely not.
Indeed. If they do come in, we'll see what that actually looks like in practice.
Because they also raising IR35 again. Is that starting to gain more traction? Because I thought that had quietened off and people didn't really want IR35 around.
Yeah, quite right. So at the moment, no one's really talking about IR35 somehow, believe it or not, after all the hullabaloo of the last couple of years. But I wonder whether that's going to rear its head again, depending on how they're going to try and define worker and self-employed all over again.
We had this absolute chaotic part of IR35 before COVID, and it did go quiet, and we did manage to sort it out. I say sort it out because it was more tax than it was employment. But I can't imagine that coming back up again. It just uses so much of HR and accountancy time. So yeah, watch and wait on that, I guess. Thank you. It's good to know that may or may not.
Quite right. I have paracetamol at the ready.
Yes, please. Thank you.
You're welcome. All right. I'm conscious of time. It's about 5 to now. So Tracy, Belinda, I'll hand over back to you for closing. But thank you very much, everyone, for your participation.
Thank you, Roy. Really appreciate all your work, as always. Anybody got any questions or anything they want from us moving forward, a topic maybe that you'd like us to discuss? No?
Oh, maybe send us an email with a poll, a few ideas and
yeah, okay. Oh, yeah, we'll do that.
Really helpful. Much appreciated to everybody for your support today, and thank you, Roy, and thank you for setting it up for us.
You're welcome. You're very welcome.
Thank you too.
Tracy, anything to add?
No, just thank you, Roy, for today. As always, it's always an eye opener, but you say it in such a nice way that it's like I could just listen to you for hours. And that's why, you know, when I was asking the question about where do you go for employment law, sometimes, as Sam was saying, there's so much out there, it can be so scary for people. And as Sam was saying, when you're quite of the younger generation, there's so much out there. Dr. Google is wonderful in some areas, but you also mentioned about AI. Unfortunately, people are going to AI and they think that that's where all the answers are, and that worries me for about employment law. So that's why I was just trying to get out there a little bit of where else can we find it, because majority of us all know about ACAS and we know that that's a great place to go to, and obviously we now know you, so we can go to your website and YouTube. Awesome. But it's just getting that name out so people know that they're actually going to get the right information, for me, is the most important, because a lot of networking events I go to, when people are talking about things to do with HR and to do with employment law, they're not factually correct, and that always worries me. So great that you could give me some information that I can then pass on correctly to others. So thank you so much for today. But yeah, as Belinda says, if there's anything that anyone can think about that they go, actually, I'm having this particular issue from a HR perspective, that we can run from Blue Stream People, then please do let Belinda know, and then Belinda will be on there to try and get the right people for you. But thank you so much, everyone, for being here today. Thank you so much for your time, Roy and Belinda, for setting it all up. Have a great rest of your day, everyone.
Thank you.
Thank you
Thank
very
you, Roy.
much.
Thank you, Tracy.
Appreciate it.
Goodbye, everyone.
Thank you, everyone.
Thanks so
Stay
much.
well.
Bye.
Bye-bye.
Cheers,
Bye.
Roy.
Bye.
Thank you
Thank
very
you.
much.
Thank you.
Bye bye.
Bye.
Bye bye.